Thank you, Member Mackenzie. We'll hand over to the ANC.
Morning, Chairperson. Member Ayanda Barnes. Member Bakubaku Force will be absent today. She's attending a doctor's appointment.
Good morning, Chairperson. Rachel van Vogel.
Thank you very much, members Barnes and Van Vogel. Do we have any members from the EFF? Al Jamar? No. Good morning to you, Namonde, as well. Namonde, do you know if we've got any apologies from any other members?
Only member Makamba Bojache from EFF.
Okay, so one apology noted. I'll now hand over to everybody else on the call to please introduce themselves. Can we start with the Department of Social Development?
Good morning, Chairperson and honourable members. It's Marion Johnson from the department.
Good morning and welcome, Ms. Johnson.
Good morning, honourable members and Chair. It's Mr. Charles Jordan here from Social Development.
Morning, Mr. Jordan. Is there anybody else from Social Development on the call?
No, Mr. Chair, an apology from Dr. MacDonald. He's, I think, attending a cabinet meeting this morning.
Thank you. Do we have guests from the WCPP here?
Good morning, members.
Chair, I'm not sure if I'm a guest, but this is Romeo Master, the legal advisor.
Morning, members. My name is Ben Gaza. I'm the senior procedural officer from WCPP. Thank you.
Anybody else from WCPP?
I'm not sure if you noted me, Chair, Romeo Master.
Yes, we've noted our guest, the legal advisor, Mr. Maasdorp.
Thank you.
We'll classify you as a guest since we don't see you all the time, Mr. Maasdorp.
Thanks, I appreciate that. There's one.
Morning, Member Philander, if you could introduce yourself.
Good morning, Chair. My apologies. I was just occupied in another engagement. Wendy Philander. Thank you.
Thank you, Ms. Philander. Is there anybody else on the line who hasn't introduced themselves from any other organization?
Good morning, Chair and members. Kululu Namasa from the Office of the Auditor General.
Thank you very much and welcome.
Good morning, members. Tepo Mutomi, Auditor General.
Thank you very much and welcome. Members, again, welcome to this meeting. The purpose for this meeting is to get a briefing by the Department of Social Development on the Western Laws Repeal Bill. That's Bill 5 of 2019. The department has a presentation prepared, and I'm now going to hand over to the department for that presentation, and thereafter we will take questions. Am I handing over to Ms. Johnson?
Yes, sir. I've put the presentation up. Hope everybody can see it.
Yes, we can.
Okay. Thank you, Chair. Chair, this is going to be an honourable members, a short presentation just to provide some context on the reason for the repeal bill and also a little bit on the legislative process that we followed. Then there'll just sort of be a brief introduction around the two acts and the sections under repeal, and then of course the Western Cape Laws Repeal Bill itself. I will also be assisted by Ms. Syria, the legal advisor in the Legislation Directorate. So if you don't mind, Mr. Chair, I think I'll just start with the presentation.
Chairperson?
Yes, Mr. Mackenzie?
Chairperson, may I please ask our colleagues from the department to put the presentation on full view mode so we can see the full presentation. Thank you.
Thank you. Mr. Johnson, are you able to just enlarge the presentation? I think it's...
Can you see it, sir?
There we go. That's better.
I just hope I don't bomb out again.
We hope that. Well, Mr. Mayor is not here this week, so should go smoothly.
Honourable members, during 2010, our Directorate of Legislation within the Department of the Premier implemented a Western Cape Legislative Review Project. The purpose was to review provincial legislation in terms of its constitutionality, obsoleteness and redundancy, and ensure that the different laws are aligned and coordinated with each other and the Constitution. There were two pieces of legislation, the Aged Persons Act, Act number 81 of 1967, and the National Welfare Act, Act number 100 of 1978, that were identified for repeal because the purpose for which they've been enacted no longer existed, or alternative legislation. Fundamentally, the legislative process to be followed was to seek approval from the provincial cabinet to draft the bill. Once the bill was drafted, we sought approval as well from cabinet to publish it for public comment. This was done. We then also published, the draft bill was published for comment, and the closing date was in September. We did not receive any comment on the draft bill, and in the provincial cabinet then approved the introduction of the bill, once certified by legal services, into the provincial parliament. The bill was certified by legal services in 2019 and introduced into the Western Cape Provincial Parliament in November 2019 again. Thereafter, the standing committee itself also published the bill for comment, and I am not sure whether any comment was actually obtained from the public or interested parties. Excuse me. The two acts which are impacted by the repeal bill is the Aged Persons Act, firstly, which makes provision for the protection and welfare of certain aged and debilitated persons, for their care and interest, for the establishment and registration of institutions, for accommodation and care of them, and for the payment of old age pensions and certain allowances. With the exception of 3 sections of this act, it was assigned to the provinces by Presidential Proclamation 7 of 1996. However, this act was overtaken by the promulgation of the Older Persons Act in 2006. That's Act number 13, which then took effect on the 1st of April 2010. And this is the current legislation that regulates the position of older persons in South Africa. And it repealed both the sections assigned as well as that not assigned to the province. It's for this reason that the Aged Persons Act of 1967 is considered to be redundant legislation on the statute books of the province, and the request therefore that it be repealed to the extent of its assignment to the province. So that is in a nutshell the position with respect to the Aged Persons Act, Act 81 of 1967. With respect to the National Welfare Act of 1978, that is Act number 100 of 1978, this act dealt with the establishment and constitution of a South African Welfare Council and regional welfare boards and committees. And the Act also defined the powers and functions of these boards and committees and provided for welfare programs and the registration of welfare organizations. The Act was assigned to the provinces by the same Proclamation 7 of 1996 However, here again, certain sections were excluded, and the sections, Chair, are listed in points A and B in the presentation. But I think in summary, these sections dealt with the establishment, constitution, and meetings of the South African Welfare Council, the functions of the council, appointments of the secretary, financial aid, and the repeal of the Community Welfare Act of the House of Representatives, 1987, Act 104 of 1987, and then also subject to continuing agreements and the making of grants to organizations. Excuse me. The sections that were not assigned to the provinces was repealed by Section 13 of the Advisory Board on Social Development Act of 2001. That is Act 3 of 2001, which has not taken effect yet. Although the Act has not taken effect, we've been advised that it does not affect the competence of the Western Cape to repeal the National Welfare Act of 1978 to the extent of its assignment to the province. Also, fundamentally, the Act does not have practical value since the regional boards contemplated don't exist, and also any matters concerning the registration and funding of welfare organizations is currently regulated by more recent legislation, amongst other the Non-Profit Organizations, or NPO Act, Act 71 of 1997. And it's because of this that it's also recommended, Mr. Chair, that the National Welfare Act be repealed to the extent of its assignment to the province. So that's just sort of a brief overview of the two acts. And finally, Mr. Chair and honourable members, the actual Western Cape Repeals Bill consists of two clauses. Clause 1 containing the schedule of the legislation that needs to be repealed, and clause 1 states the laws specified in the second column of the schedule that should be repealed to the extent indicated in the third column, and it also seeks to repeal the Aged Persons Act and the National Welfare Act to the extent of its assignment in the Western Cape province. The section in the column indicated in the respective acts that were not assigned to the Western Cape. Clause 2 merely contains the short title, namely the Western Cape Laws Repeal Act of 2019. That, Mr. Chair, just concludes the very brief introduction to the Western Cape Laws Repeal Act. Thank you.
Thank you very much. Members, I'm going to hand over directly to you. Are there any questions?
Nothing my side, Chair. It was straight to the point.
Okay. And then just maybe from my side, Ms. Marion, if you could perhaps just expand a bit more on how the Western Cape Parliament can repeal national legislation.
Mr. Chair, I need to hand you over to our legal advisor. I think she did join the meeting, Ms. Shanaz Syria. She guided the department in terms of all the legislative processes around the Act.
Thank you. I see Ms. Syria's hand. Ma'am, you can go ahead.
She must unmute herself, Chair.
Can't seem to hear you. If you could just unmute yourself.
Hi, can you hear me now?
Yes, we can.
Thank you so much. I'm Shanaz Syria. I am a state law advisor in the Department of the Premier at Legal Services, and I'm here to assist the Department of Social Development with their presentation. Chair, thank you so much for that question. Your question, if I can just rephrase, was how is the Western Cape able to repeal national legislation? That's actually the crux of the matter. When we talk about national legislation, we're talking more specifically in this instance about old order legislation. And as most of you, all of you would know, old order legislation is legislation that has been enacted on the statute books since prior to 27th April 1994. In order to understand whether a provincial legislature may lawfully repeal or amend particular provisions of old order legislation, one has to briefly look at the Interim Constitution, and I'm going to refer briefly to section 235(8) of the Interim Constitution, because it is this section of the Constitution, the Interim Constitution, that has effectively transferred executive authority power to provincial governments concerning the administration of old order legislation. So the means by which executive authority was transferred to the provinces was in terms of section 235(8), and I'm going to just try and briefly explain what the section says. In a nutshell, section 235(8)(a) of the Interim Constitution empowered the President to assign by proclamation in the Gazette the administration of certain laws to competent authorities in national governments, in the national government and also in provincial governments. These laws were assigned either in their entirety or to a specific extent. So with the two acts under consideration at the moment, they were assigned to a certain extent. Certain sections, as explained by Ms. Johnson a moment ago, were not assigned. In order to then also fully understand whether the next step in the authority, you have to look at what the Constitution says about provincial legislation. So we know that a provincial legislature will only be empowered to repeal or amend provincial legislation. And if we look at section 239 of the Constitution, provincial legislation is defined there. And I'll just read you what the section actually says. The section says that provincial legislation includes legislation that was in force when the Constitution took effect and that is administered by a provincial government. So we can see from that provision in section 239 of the Constitution that there are two legs that a provincial legislature would need to, two hurdles that a provincial legislature would need to cross in order to be able to determine whether the legislation in question that we are dealing with now, the Aged Persons Act and the National Welfare Act, whether that constitutes provincial legislation. So to address the first leg of the argument, was this legislation in force when the Constitution took effect? And the Constitution we're talking about here is the final Constitution. So we have to, we look at when the final Constitution took effect. It took effect on the 4th of February 1997, and the question that needs to be answered is whether these two acts, the Aged Persons Act and the National Welfare Act, were in force at the time. The simple answer to that question on a factual level is that yes, they were in force at the time, because the Aged Persons Act is a 1967 piece of legislation and the National Welfare Act a 1978 piece of legislation. So they were certainly in force at the time. The next leg of the argument is whether the legislation was administered by a provincial government. And this is where I have to turn to my earlier point about the Interim Constitution, section 235(8), which empowered the president to, by proclamation, assign legislation to the provinces. So by virtue of the proclamation itself, which was Proclamation 7 of 1996, by virtue of that proclamation itself, the legislation was assigned to the provinces. So this assignment actually meant the transfer of all the necessary powers to administer the legislation by the relevant competent authority, the executive authorities in the provinces. And that is exactly what happened here. So we can safely say that as a result of the proclamation and the assignment of the legislation to the provinces, yes, indeed, those two acts are administered by the province. So those two requirements in Section 239 of the Constitution are certainly met. And it is on this basis that the Western Cape and the provincial legislature of the Western Cape can indeed repeal this legislation because it has the legal power to do so. And yes, I think that in a nutshell is the answer to your question, Mr. Chair. It's a lot of technical information and there's a lot of jargon, and I'm very willing to explain anything that isn't clear.
Thank you very much. I was just working off the assumption that the current constitution supersedes the interim constitution, but I take your explanation. Members, are there any other questions? I'm also going to open up to our legal advisor, Mr. Marsdorp. If he has any questions, you're more than welcome to jump in. And then just to answer the question by Ms. Johnson around whether we've received any inputs from the public, and there were no comments received by the Western Cape Provincial Parliament during the Government Gazette publication.
Thank you, sir.
Members, do you have any other questions, or are there any other questions from Advocate Marsdorp or the procedural staff?
None from my
Yes, Chair.
side.
Mr. Marsdorp, I'm going to hand over to you.
Thank you, Chair. Chair, I heard my colleague Syria on the issue of competence to repeal purportedly national legislation. I must say that I've had quite a bit of a roller coaster engagement with myself as far as coming to grips with this issue is concerned. And Chair will recall yesterday when we had our initial meeting, just in anticipation of today's meeting, I did indicate to the Chair that where I was at the time, that the province does not have the capacity, the legislative competence to repeal national legislation. That indeed was my view yesterday. And I took that view from a reading of the proclamation, which is the basis for this engagement. And the proclamation, Chair, it says that the President may assign, take note, not the legislation to a province, but may assign the administration of a law to a competent authority. Now take note, this is a proclamation of 96. Now, there's quite a bit of history behind all of this, because this was in terms of the interim constitution. And the history for, as far as proclamations is concerned, pertained to the pre-93, pre-91 South Africa, which had national territories for Black African people. It had homelands, etc. And at the time, there were no, it wasn't a unitary entity, our country as we see it today. So that a Governor General was appointed to proclaim laws in respect of those various territories. Hence the need for proclamations. And that's why it also says that the administration of a law is assigned to a competent authority within a province. Because at the time, different territories didn't have the same infrastructure, the resources and capacity to make laws, let alone administer laws. So my initial thinking was that the proclamation only assigned the administration of a law to certain entities, which has competence and which had a jurisdiction within a province. Now, I have since read further, and because of that, I'm saying because it's only the administration of the law, not the competence to make law, I said that a province, therefore, cannot repeal what it did not legislate, because it was only allowed to administer that law. That was the interim constitution. Now, I have since read further after our conversation yesterday, and what I have encountered were two things. One was the interpretation, or rather the definition given to provincial legislation. And this is quite an express provision in the Constitution. It is a provision that is way at the back of the Constitution. In fact, it falls under general provisions pertaining to the Constitution and how certain provisions and words need to be defined to give it effect in terms of the Constitution. The Constitution, the new Constitution, in other words, the current Constitution, I should say, it says that, and my colleague Syria did refer to that. I just want to get the actual wording. It says that in the Constitution, unless the context indicates otherwise, provincial legislation includes legislation that was enforced when this Constitution took effect, and that is administered by a provincial government. In other words, provincial legislation is not just legislation that a province has made in terms of its constitutional mandate. This Constitution says it's not just that, but it's also legislation that existed before the Constitution and that is administered by that province. So, notwithstanding the fact that a proclamation says only the administration of a law is assigned to a province, which gives it a very narrow scope, the express provision of Section 239 of the Constitution now says even that, although it's so narrow, even that will be deemed to be provincial legislation. It follows then, Chair, that if we deem that proclamation provincial legislation, that it is therefore repealable, if you like, by this province. In fact, that interpretation, Chair, was confirmed in a constitutional court case of 2001, where a majority of the court in the constitutional court decided that the interpretation isn't necessarily a narrow one. In other words, a province can only repeal what it has legislated, but it should be given a more, what is called a purposive interpretation. There is a court case that underscores this interpretation, and on that basis, I am of the view that the legislation is repealable.
Thank you very much, Mr. Maestro. Colleagues, if I could just ask you, if all of you could turn off your cameras, please, just to stabilize the connection a little bit more. Members, I'm going to give you another opportunity for any questions. Any questions of clarity? I see no hands.
Covered Chairperson.
Thank you very much, Member Philander. Members, are you happy for us to then excuse the department?
Yes,
Thank you very much. Thank you very much, Ms. Johnson and your colleagues, as well as to the legal advisor from the Office of the Premier. Thank you very much for joining us.
Thank you, sir.
You are welcome to exit the meeting.
Thank you,
Thank
sir.
you,
Have a good
Chair.
day.
Thank you. Members, we will then continue, and we will now have to chart the way forward. I'm going to hand over to either Nomonde or Mr. Dasa to just chart out what our options are in terms of the way forward.
Good morning, Chair. Good morning, all the members. Ben Daza. Once again, yes, thank you, Chair. The next step now in the legislative process is for the committee to decide on its public participation process. So which means the committee now will have to decide how will it conduct its public participation process on the bill. We have published the bill in the Government Gazette, but that was just the initial publication. The committee is also required now to consult widely in the province. It must choose any mode of publication, can be newspapers, it can be social media, in any form that the committee deems fit. Then after that, the committee then will go to the formal, informal, and formal stages, which means the clause-by-clause consideration of the bill. Thank you, Chair. But the next stage now is its public participation process. That is the decision that we would require today from the committee. Thank you.
Thank you very much. Members, do you have any thoughts on what type of public participation we should engage in?
Chairperson?
Yes, sir.
I think given the current state that we are in, I presume the best would be newspapers and social media, and obviously advertise with appropriate communities affected by this. And I mean, that will be for now, and I don't know what our timelines are going to be going forward, because we are going to be in a new normal. So public hearings and those sort of things, I don't know what's the thinking going forward being about it. And if we are going to conduct in other committee oversight visits to other provinces in the next month or two, perhaps one should couple that, because I know that the Education Committee is due to visit Witzenberg. One should sort of couple that with engagement with communities without having a massive public hearing with people, 100 people attended, if you hear what I'm saying.
I hear you. Members, are you then happy to for us to go forward, noting that due to the COVID-19 pandemic, we will not be able to go out and engage physically with various stakeholders on the bill. Instead, what we'll do is we can schedule virtual public hearings and encourage our stakeholders to attend and to give input during those meetings. And that we also encourage people to make written submissions on the bill. And then we can also invite very specific stakeholders. I see Member Barnes and then Member Philander. Member Barnes? Member Barnes? While we wait for Member Barnes, can we go to Member Philander?
Chairperson, thank you. I've been mostly covered by Member Mackenzie and yourself, given the times that we are in and experiencing at the moment, Chair. Perhaps we can just also add a WhatsApp line ability for the public to engage in, and perhaps WCPP just perhaps enlighten us on what their take is on optimal public participation. What are the abilities in this regard?
Thank you. I'm going to go back to Member Barnes. We couldn't hear earlier. Nope, we still can't hear Member Barnes. Maybe Member Barnes, if you could text your comment in the chat bar.
Chairperson?
Yes, Member Van Vogel?
Just a point of clarity, Chair. I just want to know the national, if you talk about newspapers, is it also local newspapers?
I think we have to decide that.
Okay, okay.
Members, are there any other comments in terms of the way forward? I'm just worried that we can't. Remember, Barnes's hand is up, but we can't hear her. Okay, we shall move along. So, members, what we now need to just decide on, and perhaps Nomonde, do you have resolutions that you've noted that we could consider? Or do you want me to reread the ones that I've indicated?
Yes, so you can reread.
So it's that the resolutions would be that due to the COVID-19 pandemic, the committee will not be able to go out and engage with various stakeholders on the bill. Instead, the committee will schedule virtual public hearings and encourage stakeholders to attend and give input during those meetings. B, that in addition, stakeholders should be encouraged to also make written submissions on the bill. The committee will then decide on the number of public hearings and on the dates of the public hearings. Members can also advise on the different stakeholders that should be invited to the public hearings. Members will choose newspapers for where the advertisement of the bill will be placed, and we must also give reasons for choosing those newspapers. And we can make these decisions at our next meeting, which is on the 9th of June. Did I miss anything, Namole?
No, Chair, but I didn't know that those are committee resolutions, because I'm under the impression that the committee needs to decide on this meeting in terms of the number of public hearings, and because why are you postponing it to the next meeting, if I may ask?
The committee is very quiet this morning. I think it's something to do with the weather.
This is the meeting where the committee needs to decide whether you want to have public hearings. Then if that is the case, you need to identify the newspapers that we need to advertise to, and the number of public hearings and the dates for those public hearings. The other things will follow after.
Okay, Member Mackenzie?
Yes, Chairperson, I agree with Namonda. I thought in principle we agreed that we're going to have advertisement in newspapers and not public hearings per se, and virtual public hearings, if you want to call it that way. And that we don't. So I'm also trying to understand what are we going to discuss at the next meeting. I thought we're agreeing to that today.
No, I was giving you guys some time to think because everybody's so quiet.
Okay.
So members, we need to now decide how many virtual public hearings do we want to have on this bill.
Chairperson, can I?
Yes, please go ahead.
Can we do that we normally do in the different districts? Because it's virtual meetings, we can actually have one for each district, like Cape Winelands, the Karoo, the Garden Route, etc. And then because it's much easier because we're not traveling. And then on the second point, the advertisement, again, advertising in each newspaper in those districts. Obviously, we need to make sure that we cover Afrikaans, English, and isiXhosa. Thank you.
Any other comments? Okay. I'm just thinking, Member Mackenzie, we didn't have any comments when the bill was published in the Government Gazette. So would it not be more efficient to just have one, since we're doing it virtually, one virtual engagement on this, and we can invite all the members from the different districts. Mr. Daz, I see your hand.
Okay, I'm comfortable. Oh, sorry. Okay.
Okay, thanks, Chair. I think I'm covered by your input. I was going to advise the committee to look at the previous publications. I see the department also didn't receive any comments. We also didn't receive any comments. We advertised the bill from the 9th of December and the due date was 24th January this year. So we didn't receive any comments. So the manner in which the committee publicizes and engages depends also on the contents of the bill. It looks like this bill has not attracted many inputs. So, there was no input. So I kind of agree with you. Maybe Advocate Mastrop can also advise the committee, but I think one public hearing may be enough. But that's up to the committee decision, Chair.
Here we go, Mr. Mastrop.
Chair, thank you very much. As we know, Chair, the content of a bill is very much a determining factor in deciding whether there should be public participation and the extent of that public participation. In this instance, we have a bill, which is this repeal bill, which seeks to repeal old legislation. And the reason for that repeal of the old legislation is because the interests and the rights and entitlements that were contained in the old legislation have since 1996 actually been absorbed by new legislation, a new Aged Persons Act, a new Social Welfare Act, etc. So the extent, or rather the extent of prejudice is negligible as far as people's interests and rights and entitlements are concerned. So as much as the public may want to have a say, their interests are very much the same, if not better, because of the new national legislation. And I think the committee should consider that as well when deliberating on the extent of public participation. There's nothing has changed as far as interest, rights, or entitlements of any affected party is concerned. Thank you, Chair.
Am I hearing you correctly saying that the committee does not have to do public participation?
No, no, Chair, that's what I'm saying. I'm just saying that the extent should be less elaborate than had it been any other legislation where people's rights or interests may be prejudiced. In this instance, the potential for prejudice is negligible.
Okay,
That's
I see. Thank you. Mackenzie, is your hand up?
I tend to agree with the two colleagues' input the last, and I've changed my mind on that. I think perhaps 1 or 2 meetings, perhaps 2 at minimum, because whether people don't get input into a bill, and I mean, let's be fair, to publish a bill on the 9th of December and expect anyone before 15 January to give input and understand by the 24th, it's fine. But the majority of South Africans mentally go on leave on the end of November. They might be physically there, but they're not mentally there. But I fully understand the input from Mr. Daza and Mr. Masdor, and I will support 1 Zoom meeting, 1 or at most 2. And then I also think with regards to advertising, then one can just do it in 1 or 2 provincial papers covering at least 1 or 2 languages or 3 languages, because public participation is important. Whether people didn't give input into a bill in the initial stage, it doesn't mean that they can or might not do so at a later stage. But that is my view. Thank you.
Thank you. Members, are you happy with the proposal then that we have 2 public engagements on the bill and that we advertise in a provincial-wide newspaper as well as one of the regional newspapers, and that we also utilize social media and the WCPP online channels as well as all municipal channels, and that we directly communicate with the different stakeholders affected by this bill by sending out information directly to them?
Chairperson?
Yes, Ms. Philander?
I support the proposal.
Thank you.
Chairperson?
Yes, Member Van Vogel?
Yeah, I just need to add, can we also then in all 3 languages, the provincial languages, can we also then just cover that part also?
Yes, so we communicate the advert in all 3 languages, I agree.
Yeah, thank you, Chair.
Nomonde, do you also need us to come up with those dates now?
The dates of the public hearing, Chair?
Yes, do you need us to come up with those now as well?
Unfortunately, yes, because if we move forward and advertise in newspaper, that information needs to be reflected in our advert.
I'm just trying to think, how much time should we give for...
Chairperson, can I make a suggestion, please?
Yes, Mackenzie?
As the committee mandate you with Nomonde and obviously consultation with the programming committee to find a date?
Nomonde, are you happy to be co-mandated?
Yes, we can do that, Chair.
We will have a look at the parliamentary program and we'll find a date for those 2 virtual public hearings. And we will then advertise the public participation process in 1 provincial-wide newspaper as well as 1 regional newspaper in all 3 official languages of the province. Members, are there anything else? Nomonde, anything else from your side?
Nothing from my side, Chair.
Perfect. Thank you very much, members. Our next meeting is on the 9th of June. It's a joint meeting with the Standing Committee on the Premier, and we will then be introduced to the Children's Commissioner. And that will also be a virtual committee meeting. Are members also happy with us sending out a press statement just indicating to members of the public and to stakeholders that they are welcome to join that meeting?
That's happiness.
Yes, Chair.
Perfect. Now, thank you very much, members. That our meeting is then adjourned. Go well and stay warm.
Thank you, Chair. Thanks, colleagues. Bye-bye.